Edward Whelan. We're thrilled to have you with us today. Thanks for being with us. And I know now you can say hi, and then you can just start talking about the American court system in conclusion here and wrap it all up for us.
Great. Well, thanks very much, Janine, for that kind introduction. Thanks to all of you for being here. I'm just going to offer some comments at the beginning about the process of constitutional interpretation, the competing schools of interpretation, and I think that might be a way to frame some other issues. I think, as you all know, the federal Constitution is supreme over federal statutory law and also over the laws of the different states, including the state constitutions. But a big question is, what does the federal Constitution mean, and how do we go about deciding that? There's a need for some sort of interpretive methodology. No text explains itself. Even seemingly simple provisions in the Constitution, such as the statement that a person must be 35 in order to be eligible to be president, assume some answers that to questions that might not be obvious. For example, is 35 in base 10 mathematically, or base 12? And how do we know? Well, I'm going to explain a little bit what originalism is. Originalism is sometimes called public meaning originalism, but I'm going to use a couple examples to illustrate it. There's a provision in the Constitution that also concerns eligibility to be president that says, in order to be eligible to be president, you must be a natural-born citizen. That's the phrase, natural-born citizen. But what does it mean to be a natural-born citizen, and how do we go about figuring that out? You might ask yourself, just what does that text seem to mean to you? And in modern parlance, you might think that, I don't know, maybe your mother had to give birth to you by natural childbirth in order for you to be a natural-born citizen. But I think we all understand that in order to learn what that provision means, we want to go back and understand what it meant at the time that it was adopted. And that actually is the very same intuition that shapes originalist methodology generally. What we want to understand is, what did the text mean at the time it was adopted? What is that fixed meaning? There's another provision of the Constitution that says the United States shall protect each state against domestic violence. Well, domestic violence these days, for most of us, relates to the horrible situation of violence within the home. But as the context here suggests, and as we go back and discover, it actually is distinguishing violence within the homeland domestically from abroad, from foreign violence. So again, you look to the original meaning to confirm that sense. So what originalism tries to discern is the meaning that provisions bore at the time they were adopted. Let me say a little bit what originalism is not. And here it's surprising to me how many law professors don't understand some of the things that I'm about to tell you. Originalism does not mean we look only to the original Constitution. Originalism looks to all the provisions of the Constitution, including amendments that supersede provisions of the Constitution that are no longer operative. So a big part of constitutional interpretation these days is understanding what the so-called post-Civil War amendments, the 13th, 14th, and 15th Amendments mean. Originalism does not ask what James Madison would do on policy matters. It's not some sort of mind-reading exercise. It instead is trying to discover what policy discretion, what scope of discretion is left to the political branches to operate in, to pick one policy or another. Originalism is also not what some people call strict construction, and indeed many supposed supporters of originalism call it strict construction. Strict construction arose as a methodology early on to narrowly construe Congress's powers. But originalism doesn't say that Congress's powers should be narrowly construed. It simply says they should be fairly construed to mean what they would have meant at the outset. And originalism is also not a sort of hyper literalism. There's one very prominent law professor who thinks that originalism means that a woman can't be president, since the Constitution at one or two points uses the pronoun he to refer to the president. Well, we all know that there's a convention. There certainly was at the time of the framing, that use the masculine pronoun to embrace the feminine. So even though it may well be that no one back then was contemplating a female president, certainly there's nothing in the text of the Constitution that forbids that, and it'd be ludicrous to contend that originalism does. There are various versions of originalism, different flavors, if you like, offered by different ideological schools. There's a very robust progressive originalism. There's a libertarian originalism. There's a sort of natural law originalism that seeks to infuse, or I suppose its proponents would say, discover natural law principles in the Constitution. And there's what I would call a judicial restraint school of originalism, probably the one that I'm most subscribed to, which basically would say that where the Constitution, where the original meaning doesn't speak clearly to something, judges can't override what happens in the democratic process, and they need to restrain themselves and let the democratic processes operate. Very briefly, alternatives to originalism go under different labels. They exist on both the political left and the political right. Sometimes efforts to make moral readings of the Constitution, to read the Constitution to be to achieve the moral goods that folks on either side wanted to achieve. The dominant effort of the last few decades, the dominant alternative to originalism has been something often called living constitutionalism. It's a notion that, gosh, this Constitution from more than 2 centuries ago is obsolete and can't operate in modern America. So we need to try to update it by reading its provisions not as they were originally meant, but infusing them with our own meanings that will be sufficient to enable the branches of government to meet the challenges of the day. In practice, it actually operates contrary to its promise of flexibility. It tends to be the vehicle for entrenching certain favored rights in the Constitution in a way that prevents the democratic processes from operating. In any event, that's a quick overview of what originalism is and what it's not. I would encourage you, if you like, to consult any of the volumes of Justice Scalia's work that I've compiled, the most recent of which is called The Essential Scalia.
Okay, The Essential Scalia. That the sun just started barreling down in my room here. I have many questions, but Elizabeth, I forgot, sorry. We need to introduce our sponsor for the day, because without our sponsor, this wouldn't even be happening. Briefly.
No worries. Sorry about that. Thanks so much, Janine. So we really want to thank our sponsor today. Bruce Ledbetter has been a generous sponsor and supporter of Constituting America, and has really just provided such invaluable advice, given great introductions to potential collaborators, and has supported our program since 2010 when Constituting America launched. And so thank you, Bruce, for all the ways that you help bring Constituting America to life. We just also want to remind our listeners that as the end of the year approaches, all of your gifts are fully tax deductible, and you're able to give a gift in honor or memory of a loved one. We've made that possible this year. And so if you'd like, you can go to the big red donate button on our website and help us reach even more students in 2022. So thanks for being the wind of our wings.
All righty. Okay. Just wanted to get Bruce Ledbetter in there, because Bruce Ledbetter, I know you. I've known you since 2010. So thank you so much for everything you've done for us. We appreciate you. And sorry, I slipped my mind. Okay. I was so excited to get to this, Mr. Whelan, about all this constitutional interpretation. Well, okay. You broke down what the living Constitution and the different forms of originalism. So can you break down the 4 different types? You said there was a natural law, maybe originalism. There was a libertarian originalism. Can you break those down again?
Well, sure.
Just like bullet point for me real quick, then I can come with my
Sure.
question.
Well, I identified 4, but different people might identify them differently. But I identified progressive, libertarian, judicial restraint, and natural law. And they really, in some ways, I mean, advocates of each might actually agree on some foundational principles and simply disagree on how they read the evidence of what certain provisions mean. But there's also some disagreement in methodology that can lead in different places. For example, libertarians tend to say that that where there's any doubt as to what a constitutional provision means, the constitutional provision should be interpreted as prohibiting democratic action in the name of liberty, a highly dubious proposition in my view. But in any event, these are different, different folks coming from different directions have a natural tendency that we all need to guard against reading our own views into the Constitution. And as an advocate of the judicial restraint version, which I think most clearly avoids doing that, I confess I'm a little suspicious of the progressive libertarian and natural law flavors.
Interesting. Okay, so give me a one sentence natural law they believe.
Well, you can have advocates of natural law originalism believe all sorts of different things, but natural law originalists are more likely than any other group, I think, to believe not only that the Constitution doesn't create, say, a constitutional right to abortion, but that it affirmatively forbids permissive abortion laws. Whereas those of us who are advocates of judicial restraint, on the whole, inclined towards the view that the Constitution leaves that matter to the political processes to be decided one way or the other.
Okay, that's interesting. Okay, so now we have natural law, we have judicial restraint, which is you just essentially it's just what it is, judicial restraint. You're gonna like restrain yourself from getting really involved politically and let the legislative branch have more say. That's cool. Okay, so then what was the other one?
Well, progressives. So progressives would be inclined to read Congress's powers very broadly. Not only the powers set forth in Article 1 of the Constitution, but also the powers that Congress has under the 14th Amendment, under the 15th Amendment, to take actions to enforce the provisions of those amendments. So it's generally true that progressives want to give again want to read Congress's powers very, very broadly, and also read also there's a tendency to read the equality provisions of the Constitution very expansively. Now, again, they would say they're reading them properly expansively. That's by identifying these different variants. Although I obviously think the one that I subscribe to is the accurate one, I don't mean to be answering the question about what errors there might be in the others.
Okay, but so judicial restraint in regard to the legislative branch, the progressive originalists think that Congress has a wide power. The judicial restraint, what is their view of the legislative branch then?
Well, judicial restraint might share with progressives a tendency to defer to accept broad views of congressional power. I think that advocates of judicial restraint would be much more likely also to accept broad views of state legislative power, where progressives would tend to be more hostile to state exercises of power, at least if they're not in a exercise in a progressive direction. These are all broad tendencies, and I'm sure everything I say here, someone could fairly quarrel with.
That's what I'm learning about the law. The law is somehow it's not as black and white as you would think. Okay, so I think I've got that with both progressive originalism and judicial restraint. The legislative branch has power that the natural, these are broad topics. This is not written in stone. The natural laws, they get very, very specific and hold on to things in the Constitution. And what's the fourth one? I just answered that and I want to turn it over to Tova.
Libertarian.
So what's their view? What's their view of Congress? Let's just stick to that comparison.
Well, libertarians are the most likely of the four to read Congress's powers, as well as state legislative powers, very narrowly.
So they don't want as much power in the Congress, the libertarians.
To read rights provisions very expansively.
And natural law in regard to Congress, what does natural law think about Congress?
It's hard to tell. I don't know. It's going to vary with different advocates. I think natural law advocates are less committed to one view or another of congressional power.
Interesting. Okay, really cool. I would love to understand that the natural law in regard to Congress. They just don't have a feeling about it one way or another.
Well, I'm reluctant to just try to speak too much in their behalf.
I mean, in a broad term, I'm not being specific. I'm very clear about the judicial restraint, libertarian, and progressivism in regard to Congress, but I don't understand natural law.
You may be more clear. You may be more clear than you should be, because these are just very broad tendencies I'm trying to outline. I think that look, you could imagine an advocate of a natural law view of the Constitution arguing, say, in the days when slavery still existed, that Congress ought to be deemed to have power to forbid slavery in the states. So that would be, because that would, promote the public good of ending slavery. Now they might be, again, more inclined to favor exercises of power that advance what they see as the common good, and oppose those that don't. They tend to rely on non-textual limits, things that they think are somehow inherent in what the nature of law is. But I hesitate to try too much.
Thank you for going there with this, because it's really interesting. I think you also said judicial restraint tends to favor the states, where it sounds like natural law is a little more natural, a little more federal in certain respects. But I know you can't pin any of this down. But that was really interesting. That was really interesting, and I just learned a lot. So thank you. Okay, Tova, it's your turn. And wait to hear everybody else's questions, because everybody comes at this from sort of a different perspective. I kind of outline it for the youth on our show, but you'll love Tova and Jewel and Jordan's questions, and our audience as well. So thank you so much. Okay, Tova.
Thank you so much, Janine, and thank you so much for being on. I was wondering, we talk about judicial restraint, but I've heard the phrase judicial activism quite a lot. Could you talk about what that is, and is it completely at odds with originalism, or are there any elements of it in originalism?
A very good question. I'll say that the term judicial activism tends to be used by many different people in many different ways, often simply to identify a ruling that they don't like. I use the term a lot, write about judicial activism a lot, and try to give it principled content. And my definition would be that a ruling is judicial activism if it wrongly overrides a democratic enactment. In other words, wrongly blocks say a state law from operating. Now, I readily concede that definition begs some very important questions. What does it mean to wrongly block a law from operating? And that's where you have to get into the debate over what's the proper interpretation of the Constitution. So the distinction I would make between, one can imagine, and here I'll give 4 other categories, but you have the error of judicial activism. I use the term so that if we use the term judicial activism, it's always an error. You have, at times, of course, it's proper for courts to block democratic enactments from being enforced. And so I would call that, if you like, I don't know, judicial action or exercise of judicial review. Then you have, so I'm sort of moving from left to right, so to speak. Judicial activism, then proper judicial action, then judicial restraint, which is also sound, which is properly deferring to the democratic enactments, not blocking them, but allowing them to take place. And then past that, something I would call judicial passivism, the courts being too passive in not blocking enforcement of laws that the courts ought to be blocking. I think it can be useful to think about those four categories. But again, there's going to be lots of debate in any particular case over which category it might fall into. Though, if the decision is blocking a law from taking place, the question ought to be: is this wrongful judicial activism, or is this just a proper exercise of judicial review? And if the decision leaves the democratic enactment to operate, is this a proper instance of judicial restraint, or is this a wrongful exercise of judicial passivism? I emphasize I'm saying passive. I've been quoted before talking about pacifism, as though it's as though the court is being peaceful and not going off to war, but passive, not pacific.
Thank you. That really clears it up. And then I was wondering, looking at this from a global perspective, do other countries have a conception of originalism with regards to their constitution, or is that a more American idea?
Well, that's a very interesting question. I am not, can't claim to be all that knowledgeable about the constitutions of foreign countries. My understanding is that many of them are very recent. And of course, there are countries that don't have constitutions at all. What we think of as constitutions, they don't have something written down that defines who does what. That, is a situation with the United Kingdom, for example. I guess France, on its fifth republic right now, must have had its constitution set forth, less than 100 years ago. And that's probably true for a lot of other countries. Justice Scalia liked to emphasize that there are plenty of countries that had constitutions that promised all sorts of things, promised housing and good food and extra ice cream. I guess I'm joking about the last one. But they did not have the structure and the political culture to actually make those rights real. So, for example, if you look at the Constitution of the Soviet Union, promises of healthcare, all sorts of things, but it's meaningless paper in practice.
Yeah, absolutely. That's a really good point. And then just to understand the kind of mechanics of originalism, does originalism hold like court precedent as like equal to the Constitution, or does it always hold Constitution supreme?
That's a great question. I think originalism is rooted in the recognition that the writtenness of the Constitution is especially significant. That said, I don't think that originalists among themselves have agreed on a principle or an approach to precedent, or stare decisis, as we lawyers pronounce the law Latin phrase for adherence to precedent. I don't think there's any originalist who would say that precedent trumps, that precedent always trumps the Constitution. But there will be some who might be more ready to defer to precedent than others would. Justice Thomas, who is now that Justice Scalia is no longer on the court, the most prominent originalist justice, has said that he's inclined to give little or no weight to wrong precedent, that especially if something is, in his terms, egregiously wrong, it's incumbent upon the court to avail itself of the opportunity to overturn it. But again, no justice, originalist or otherwise, has really spelled out a very coherent view of precedent that isn't, wildly manipulable. And no justice has ever taken the position that precedent simply can't be overruled.
Great, thank you. And I'm sure this is a question originalists get a lot, but I'm just curious to hear the response. How would originalists respond to the question that, like, with our very changing world, obviously our country has changed extremely since, in the last 250 years. We have many more people. We don't have slavery and other issues like that. So why is it still so important to adhere to the Constitution and the original ideas of the founders? And how do we believe that the Constitution will kind of indefinitely apply to a very changing world?
Sure. Well, of course, as I mentioned at the outset, originalism recognizes the amendments, including, of course, the hugely important post-Civil War amendments that specifically abolished slavery, established equal protection. So, without the 13th Amendment, the whole slavery question would theoretically be up for grabs. I identified these different schools of originalism. What those of us who embrace the judicial restraint school would say is that originalism properly applied gives very, very broad play to the political branches, so that there's lots of flexibility to adapt to changing circumstances. And we would argue that it's living constitutionalists who in practice deny that flexibility and try to impose preferred rights that prevent the political processes from changing positions over time, for example. Look, there are questions, especially when it comes to Congress's powers over how broad are those powers? Does the application of the meaning of those powers change over time, given the way our economy has changed? I mean, depending, for example, how you understand the Commerce Clause, it's quite possible that when you have an integrated national economy, you would think that the Commerce Clause might reach a lot further than it did 200 years ago.
Great, thank you. And then, we know the Constitution is the world's oldest and shortest constitution. So why do you think it's held up for so long and so well?
Well, that's a very interesting question too. I mean, the shortness has to be part of the virtue of it. That is, the Constitution, unlike other constitutions, including state constitutions, doesn't get into a lot of minutia. The very word Constitution is designed to suggest that we talk about a person's constitution. We mean, does that person have a healthy body? Are the arms in the right place, for example? So much of the Constitution is about how we structure government, how you elect members of Congress and the president and get justices on the Supreme Court, how a law is enacted, just process questions that can seem very dull, but that are hugely important in practice. But I think part of the answer to your question just has to relate to our political culture as well. We have for a long time now, revered the founding, the Declaration, and there's been this deep patriotism that I think helps respect for the Constitution. And so I think that's one aspect of its, one cause of its permanence.
Great, thank you. And for my final question, I wanted to know who you'd say the most influential originalist thinkers are today, if someone wanted to learn more about that philosophy.
I mean, despite his death, I would say that Justice Scalia remains very influential as an originalist, and part of what I've tried to do in the books of his collected works is spell out, present his views. Justice Thomas is obviously another, and then there are lots of academics, law professors who can spell out different views in different places, often at odds with each other. One of my favorites is a fellow named John McGinnis, who's a law professor at Northwestern. Another is Michael Paulson at the University of Minnesota. But other people might pick some very different names.
I just want to pop in for two secs. I don't want to take any of Jewel and Jordan's time. Thank you, Tova. Always wonderful questions as always. Who just got into Georgetown University and she's so excited. She has many. That's just one of her first responses. She has lots of other college applications.
Well, stop by when you're. Oh, you haven't committed. Okay, so if you're in DC, let me know.
Thank you.
Okay.
I'm really excited.
Yeah. Well, it'd be great for y'all to meet in person. So the Justice Scalia, and I'm really conscious about taking Jewel and Jordan's time, but I do want to say in regard to why the Constitution matters today, which I think perhaps was more of a legal question from Tova's perspective, but Justice Scalia was very verbal, was he not, about the Bill of Rights is a wonderful thing, but the Magna Carta had existed before. But what's great about America is the checks and balances. So really, I mean, you can say this in the Constitution doesn't really matter anymore, or this or that, but it's the checks and balances, even down to the House has in the Senate have to approve the same bill, and then it goes to the president, it goes back. Those things are timeless. That I think that Justice Scalia was really talked about that quite a bit. That's why the Constitution matters, because if we lose all those checks and balances, and even from the judicial perspective, we lose our freedoms, and then we don't have anything.
Yeah, absolutely. What he might call the structural Constitution. He said in one speech, structure is everything. We talk about separation of powers among the three branches at the federal level, and then federalism, the division of authority between the states and the federal government.
Yeah, which actually means there's respect for each other there in federalism. Yeah.
Right.
Okay, thanks. Okay, Jewel and Jordan, see, that didn't take too much time. Just wanted to kind of throw that out there. Okay, go ahead, Jewel and Jordan.
All right, I have a question that arose as you've been talking, and I'm wondering how to consolidate, I guess, the two ideas. We spent a long time talking about the founding of this country, of course, on constitutional chats. We spent quite a while talking about natural law, articles of confederation, and many of the things that developed into this court discussion. So, not taking a natural law view of originalism, where does someone like yourself find the authority for the justice system placed? How do you justify then the authority the justice system acts within the system?
Great question. May I ask, are you Jewel or are you Jorn?
I'm Jewel.
Okay, great. I just want to make sure I had you guys straight. Well, let me offer sort of one clarification that I perhaps should have made earlier about what I'll call judicial restraint originalism, which is there may well be, indeed there are, natural law concepts that are embedded in certain provisions of the Constitution. And you can see, for example, I suppose the easiest to perhaps the easiest to recognize is the right to freely exercise one's religion. I think that's very much a natural law concept. So an advocate of judicial restraint will, or any originalist will seek to understand what the meaning of that provision is and give it effect. And what the dividing line, which between what I'm calling judicial restraint originalists and natural law originalists, is that, and it may well be that natural law originalists will reject the characterization I'm about to give, but they seem much more ready to rely on things outside the Constitution, their own concept of natural law, or something in the Declaration of Independence, to impose meaning on provisions of the Constitution that don't otherwise seem to bear that meaning. So that can be a very fine distinction in practice. I do want to make clear that there are many of us who are proponents of judicial restraint originalism who believe very strongly in the existence of natural law, who believe in right and wrong. We're not moral relativists at all, and indeed that's an epithet that the natural law group will often fling in our direction. But no, we believe that that the Constitution itself reflects a sort of moral principle that power is to be divided among the three branches according to discernible principles. And
it seems like that what you just said about the Declaration, that is certainly a dividing line, though, because we've heard from many people who have described a view where you can't separate the Constitution from the Declaration. And it's been persuasive because if we're trying to understand what those words objectively meant that the founding fathers write, it's hard to not then take into account what we knew they understood the words to mean. And while there was no uniformity of philosophy, we know that they were coming from an understanding of development from the Magna Carta, from philosophy of Kant and Locke, rooted in somewhat taken from Bellarmine or Suarez, which is Aristotelian. And it's not so much a shot in the dark, it's more so we can make explicit claims rather than implicit claims on what their meanings were in even constitutional terms that are more so found in the Declaration.
And where that's so, judicial restraint originalists would respect and implement that. Sometimes it's easier, I think. I mean, I find whenever I have discussions with natural law originalists or natural law non-originalists, as most of them, a lot of them don't describe themselves as originalists, I get lost in the abstractions, and I always want to hear, okay, let's get to a concrete dispute, and let's see in this concrete dispute how the principles play out. I mentioned before well, let's take the issue of marriage. I've had some natural law advocates suggest to me that the Constitution should be read to forbid states from, say, changing their marriage laws to redefining marriage to allow same-sex marriage. I spent a lot of time making the originalist case that a lot of time and energy, and made a lot of enemies, making the originalist case that the Constitution itself does not entrench a right to same-sex marriage, but instead leaves that matter to the states to define. So here's a pretty sharp difference. I don't see anything in the Constitution that says states can't define or redefine marriage as they see fit. At least some natural law advocates would say that marriage needs to be defined by positive law as a male-female union, and any law that doesn't do that is A, bad, and B, unconstitutional. And certainly,
I guess my question, that's a good example, because it is concrete. So then because I actually don't know this answer, I know there's been laws where the federal government then recognizes marriage, but is the word marriage in the Constitution?
No, it's not. And
I guess so hypothetically, if the word marriage was in the Constitution, then from what I said before, then I would have to understand marriage as to mean what that word means, because we could only understand same-sex marriage as not a modification, but a complete redefinition of the term. It's not necessarily, so when you spoke of moral relativism, I can kind of understand the claim if we're talking about changing a philosophic principle, like revolutionizing something that did not previously exist in marriage or abortion or these other things, are examples of that, because it's not necessarily where it's not in where it doesn't speak on it. It's to natural law originalists, if that's the case. It is the foundation. It's more than assumed. It's almost the foundation of what the entirety of the law is built on.
Yeah, and again, if I could provide a concrete example that I think would show our agreement and perhaps go beyond that. Let's say the Constitution had a provision adopted in the original Constitution that said the states shall have an obligation to preserve the institution of marriage. Then, it seems to me that again, one would have to look at the originalist evidence, but there'd be plenty of reason to think that what they're talking about is the perennial understanding of marriage as a male-female union. Let's say the Constitution instead said the state shall have freedom to define or redefine marriage as they see fit. You can have the word marriage, but in the context, it seems designed to confer flexibility. At the very least, you say, well, polygamy that might well give a state, the freedom to adopt polygamy. There'll be a question that, again, even then, how capacious that term is, whether it would include same-sex relationships or not. But my point is, it's not just a question of whether the word marriage is or is not in the Constitution. It'd be a question of what does the constitutional provision say, and how would we have understood that back then?
So then you would think that from the perspective of a judicial restraint originalist, the federal government doesn't necessarily have any right to tell the states exactly what to do on that topic.
Right.
So
with
the
the
states have primacy over that.
Right, with the Constitution as it is. Now, again, there are cross-cutting principles that can come into play. For example, the proposition that the Equal Protection Clause means that states cannot discriminate on the basis of race. It follows from that laws banning mixed race marriages are unconstitutional, and that's true not because there's some sort of general protection of marriage in the Constitution, but because there's a general protection against racially discriminatory laws.
I think Jordan's got. I could definitely keep going for a long time. It's interesting. Jordan's got to ask a question though.
I'm just a little. It's kind of hard to wrap my head around the fact that so much of this talk and these rules of thoughts is purely based on how you take the Constitution, your interpretation. So I just want to know if you could dive into that a little bit, because, having the option of interpretation.
How can someone who thinks this and this even communicate?
Yes, and really, how can you honestly communicate about these things and come to a real conclusion?
Like, forget about
purely interpretation.
Yeah, like if it wasn't an originalist talking to each other, how can you have that communication with a living constitutionalist?
Well, that's a great question. The way I sometimes put it is, how can one ever say that a living constitutionalist position is wrong under living constitutionalist principles? That is, if the Constitution, the way I see it, living constitutionalism is completely indeterminate. It can mean whatever people want it to mean. There's no methodology that can be set forth. It's just a judgment about what the time demands, what the climate of the age calls for, to borrow from Ruth Bader Ginsburg. So you're right that certainly between originalists and non-originalists, if you disagree on basic methodological principles, your disagreement is right there at square one. Now with originalists, there's room for the non-originalists to come back and say, you're not being faithful to your own originalist principles. Here's all this originalist evidence that, according to the methodology you've explained, cuts in some other direction. So there's room for them to say, you're wrong under your own principles. But that's different, I think, from the what I call the step one disagreement on what those principles are. Now, for better or worse, at this point, 200 and whatever it is, 40 years into our country's history, we have a lot of Supreme Court precedent on the books, and most cases, well, first of all, many cases the court decides don't involve the Constitution, don't involve disputed constitutional questions at all, and many of them that do are dealing within the context of previous court rulings, trying to understand how those rulings apply. So there, everyone is on the same playing field, so to speak. Now, it may be that one side or other will say, well, those precedents are wrong and we ought not follow them. But at least insofar as they're arguing about those precedents, they're dealing with each other about what those precedents are best understood to mean. And again, when it comes to non-constitutional cases, well, actually there, when you're dealing with statutory cases, you have a somewhat similar divide between originalists and non-originalists. The labels are different for various reasons, but I think the divide is largely the same. That is, in the context of statutory interpretation, we talk about textualism. But again, that textualism means, what did the text mean at the time it was adopted? It doesn't mean what might that text seem to mean to us today. So it's a very originalist textualism. And the methodologies that reject textualism come under names of purposivism. As we look to the broader purpose of the statute and read all the provisions of that statute to advance that broader purpose, and if something doesn't make any sense, we just ignore it, override it. Or pragmatism, which is very, very similar. Let's try to make things work. Justice Breyer is very much a professed pragmatist. So was a prominent appellate judge by the name of Richard Posner. And what's interesting is that you have these two pragmatists, and Posner harshly criticized Breyer. So the pragmatists don't really have much. If a living constitutionalist disagrees with another living constitutionalist, how do they even have that argument? If one pragmatist disagrees with another, it's difficult to know what they're arguing about as well.
All right, thank you. I think it's time for some audience questions, right?
Great, thanks for the great questions.
Yeah, I told you it was going to be very. Okay, I do have a question for you, because you touched on something that I think could be great for the American culture to hear your response to this. And it builds on Jewel and Jordan's question. You talked about, and I caught this, and I would love for you to just say a minute or so on it. You talked about when a conversation becomes abstract, you can't, where do you go with that? But you bring the conversation to something concrete, and then you can have a discussion. And I think that's rather brilliant. And I think that sums up what's happening in our culture today. Everyone's talking in abstractions, and they're not talking in concrete. And if we would just talk about in concrete measures how you deal with things, then I think we could have a conversation. And I would love to hear your thoughts about that.
Well, it might, in some instances, it might lead to more agreement. In others, it's just more disagreement. But I'm not burdened with a deeply philosophical mind, and my impression is that so many philosophers end up having disputes where they simply have disagreement in what terms mean, and they never really explore that. And I find that the concrete specific example is a good way to make sure that we're actually talking about the same thing.
So give me an example, just for if we have a high schooler on or something, and give us an example of you just said it with the philosophers, but let's take a broad subject today that might be abstract, and give our youth an example, and then how to take that more into something concrete. As you say, it doesn't mean I'll agree, but at least we can get down to sort of business here. Can you give us an example of that?
Well, I'll try. Maybe some of the questions, maybe Toya or Jordan and Jewel can come up with something faster than I can. Let's see. Well, I guess we have so much contention right now over vaccines and mandates and things, and I just find that's an area where people tend to lock into certain general positions, and I wonder whether they wouldn't have much more agreement on some specifics. For example, I think that lots of people who are very pro-vaccine and even very pro-mandate might be very ready to recognize religious exemptions in the same way they recognize medical exemptions for folks who who have conscientious obstacles to the vaccine. I don't know, maybe I'm wrong. Maybe when you get down to nitty gritty, the fights just become more intense. I suppose it depends on the issue. But that's one that comes to mind, where I'd like to think that the more specific we are in actually trying to craft a policy, the more we might be able to find at least some common ground.
Yeah, and I'll toss it to Elizabeth here, but the abstract seems to be, you know, a generalization where you just think principle. Concrete seems to be, let me actually look at the human being. Let me listen to like exactly what they're feeling and what they're thinking. And when we start getting down to that, humanizing something, I think it helps the situation.
Yeah, of course, I think the particulars need to be informed by principles. I'm not suggesting otherwise, but when it comes, but you know, people with different principles can come to agreement. And you know, in many ways, the friendship between Justice Scalia and Justice Ginsburg was a very nice example of how, without sacrificing their principles, and I'm not saying they often came to agreement on the law, but they could at least like and respect each other. And it's I think very sad that we seem to have a political culture among the young, especially, where if you don't subscribe to a particular set of beliefs, you know, you're to be condemned.
Mm-hmm. Yeah, and I wonder where they learned that, though. You know what I mean? I'm not pointing out parents. I'm just saying, you know, they're just replicating what they're hearing and being taught. Elizabeth, you got like 2 minutes here.
All right, I'm going to go with the most concise question. You can take this any way direction you like. What's the oldest law?
What is the oldest law? Well, I
That's
guess
from Joseph Crooker.
Okay, well, I guess I will happily say the oldest law is that written on the human heart. So, you know, I subscribe to natural law in some very fundamental way. Beyond that, I don't know whether you know, Hammurabi or you know, I don't know who would have the historical claim. I don't know the answer.
Oh, I've watched all that. It goes so far back. Oh my gosh, but Hammurabi is one of them. That's so true. Oh my goodness. Did that do it? Yeah, wait, you have 2 more minutes, Elizabeth. Go for it.
Oh, great. Okay. All right, let's do it. So Gary Helmbold is asking a question about the intent of the framers, and can we not understand their intent by studying the articles and letters and the Federalist Papers and Washington's Farewell Address?
Sure. Now, there's actually a division within originalism between so-called original intent originalists and original meaning originalists. I hate to get too arcane here, but imagine, for example, that we could come up with compelling evidence that that when the drafters of the Constitution said that the president must be at least 35, they actually meant base 12, and they said just keep it secret. We don't want anyone to know. Well, original intent originalists might say, okay, well, that intent is that now that we've discovered is actually binding. Original meaning originalists would say that private, you know, secret anti-textual intent is meaningless. But in most instances, original meaning originalists would draw a lot of interesting insights from the intent of the framers.
And John Holmes had a question. It seems that Congress ignores when things are declared unconstitutional at times. Is there a way to sort of get their attention, or without bringing lawsuits, you know, to determine whether something is constitutional or not?
Well, I could talk about this question for an hour, and I'm going to actually take it in a somewhat different direction, which is Congress is not bound by what the Supreme Court says. Congress is an independent branch of the federal government. It owes respect to the Supreme Court's interpretations, but it's authorized in the same way, say, President Lincoln had the authority to say he wasn't going to accept the principles in Dred Scott. You know, he was going to deliver passports to free blacks, notwithstanding the Dred Scott statement that free blacks can never be citizens. So I don't think. Look, I wish Congress paid more attention to thinking about what its constitutional responsibilities are, but I wouldn't embrace the proposition that Congress needs to accept whatever the Supreme Court has said on constitutional questions.
Thanks.
I'm so glad you said that. I'm always, people aren't aware of that. In closing, Mr. Whelan, you were fantastic today. They're not aware. The modern thinking is the Supreme Court's the be all end all, the final decision, and they don't know that there's actually, no, it's not the final. That was wonderful. You're terrific. Thank you
Oh, you're
so much.
kind. Thank you.
Wait, gosh, very intellectually heady conversation we had here today.
Oh, great questions. Very, very impressed with all of them. Thank you.
Aren't they? I told you when you start hearing Tova and Jewel and Jord in our audience through Elizabeth, it was going to be unique. And
You too.
oh, thanks. I consider mine pretty elementary. I'm just laying it out. I'm just setting the foundation. But I look forward to meeting you. So thank you so much, Mr. Whelan, for being on the call today.
Thank you
And
all.
for all you. Okay. Yeah, and so Jewel and Jorn, so you want to say goodbye, and Tova?
Bye-bye. Thank
Bye,
you,
everyone.
everybody.
Thanks for tuning in.
Bye, everyone.
Merry
Thanks for being
Christmas.
on. Happy holidays and Merry Christmas.
Yeah, happy holidays, Merry Christmas, everybody. We'll see what our first show is January. Let's look it up.
January 4th.
There you go, January 4th, and we're
Great.
starting on economy. It's going to be fantastic. A whole series on the economy. What's the Federal Reserve? What was the National Bank? What's Wall Street? Explain it all to us. All right, talk to you later.